It's 2019, and in terms of Indian political history, it's a pivotal year. There are three legislations that came in which would make their way into our history books.
Bharat Mata Ki!
The abrogation of Article 370.
Article 370, which grants special status to Jammu and Kashmir.
The Ayodhya Babri verdict. And CAA.
Hindu, Buddh, मैं इस बिल को फाड़ता हूं, ये हिंदुस्तान को तोड़ने की कोशिश कर रहा है.
The first two resulted in their respective political stirs, but were largely accepted by the public. Willingly for some, unwillingly for others. But the CAA was different. It's the month of December. The bill gets tabled for the Parliament's winter session and is passed within a day. But the people are not happy. And this time round, they decide to speak up.
Police in India are facing criticism for a heavy-handed response to students protesting a new citizenship law.
Tens of thousands of protesters in various parts of the capital joined the outcry against what they say is divisive and discriminatory legislation.
The Citizenship Amendment Act, or CAA, is the most recent change made to the Citizenship Act in India. It adds a key provision to it: the right to apply for citizenship to these 6 religious minorities from these 3 countries that came to India fearing religious persecution. The cutoff date for entry into India for this provision is on or before the 31st of December. Now, CS actually proposes a benevolent measure. The government said that we are merely offering citizenship to a certain group of minorities facing a certain kind of persecution. And we are not infringing on the rights of others.
मुस्लिमों के अधिकार ले लिए. इस बिल ने किसी मुस्लिम के अधिकार नहीं.
हिंदुस्तान के मुसलमान के विरोध में नहीं है.
मैं देश के मुस्लिम भाइयों से कहता हूं, किसी के बहकावे में मत आइए, मत डरिए.
And why did the entire country erupt into protest? Why was CAA called discriminatory, anti-secular, and anti-Muslim? What's the problem here? To understand CAA, we must jump into the story of citizenship in India. There are 3 main parts to it: NRC, NPR, and the CAA. Now, the story begins on a very secular note. India was born out of a bloody partition based on religious violence, but the Constituent Assembly made sure that citizenship in the country be strictly defined in secular terms. So even though there were treaties like the Nehru-Liaquat Pact, wherein the Indian government concerned itself with minority rights in Pakistan, when the Citizenship Act was passed in 1955, its terms were not linked to religion. The first big revision to citizenship in India happened in 1985, the Assam Accord. Some quick context. Assam has had a history of migration, political instability in the border state, first East Pakistan and then Bangladesh, meant an influx of refugees. This gave rise to a long-standing students' movement against this influx and resulted in a series of violent events like the Delhi massacre. It is in response to these movements that the centre signs the Assam Accord. The treaty marks 1971 as the cutoff date to determine the citizenship of these migrants. Those who came before 1971 would be offered the provisions of citizenship in varying forms, while those who arrived after would not be considered citizens. That's where NRC comes into picture. The idea of NRC was simple: a register of citizens in India. The Assam Accord, for the first time, categorized who is a citizen and who is not. The next big step in this citizenship story was the 2003 amendment. Building on this idea of citizen-non-citizen, it introduced the term illegal migrant to the Citizenship Act. In effect, the idea of NRC was extended to the entire country. The amendment mandated the government to maintain a national register of citizenship and issue national identity cards to those registered as citizens. Illegal migrants would be ineligible for this. Plus now, citizenship by birth was also restricted. For those born after 2003, citizenship would be granted on the condition that one of the parent is a citizen of India and the other is not an illegal migrant. Which means that if a child is born to one Indian parent and one illegal migrant, he or she becomes stateless. This NRC would be preceded by what is called NPR, or the National Population Register. The 2003 rules made provisions for this as well. The NPR would simply be a list of usual residents, that is, anyone residing in the country, whether citizen or non-citizen. The data from this population register could then be used to make a register of citizens. So what do we have so far? The Assam Accord and the 2003 amendment that makes the distinction between who is a citizen and who is not a citizen. To put this into effect, you have the NPR that offers to count everyone residing in the country, followed by the NRC, which can then filter this data, separating the citizen from the illegal migrant. But it's not as simple as it sounds. When put into practice, things get a little more complicated. Let's take a look at Assam. A few months before the CAA was passed, Assam's final NRC list was announced. Of the 3.3 crore applicants, 19 lakh people did not make it to the list. So now you had your citizens and you had your so-called illegal migrants. Of these alleged illegal migrants, the list was suspected to have more Hindus than Muslims, which created a problem. The BJP, that had just won the general elections in May 2019, with the politics of Hindu identity at its core, didn't know what to do with this NRC. So it first rejected this NRC, then promised the Hindu migrants the option of CAA. You remember what CAA does? It essentially offers the right to apply for citizenship to some. Now, at a country level, of all the illegal migrants that NRC would reveal, CAA potentially offers a way out to these 6 religious groups from these 3 countries. It changes their status from illegal migrants to persecuted religious minority. And in this whole exercise, what's the most significant group that gets left out? Yes, it's the Muslims. Now, the Pan-India NRC is yet to take place. Many state governments have refused to implement either the CAA or NRC or both. Even in Assam, the ground zero of the NRC exercise, there is no further action been taken yet, and the fate of the 19 lakh people that didn't make it to the list is stuck in limbo. But despite all of this, the CAA is still very much a law of the land that awaits being notified. So let's look at it a little more closely. The first question that we can ask of this law is, why choose these certain groups? The government claims that it is on the basis of persecution. These religious minorities are seeking protection in India on account of facing religious persecution. And so the Indian government is responding to their special needs with a special law. Which begs the question, what about other communities excluded from this list who are also facing persecution in these same countries? There are the Ahmadis, the Shias, the Hazaras, or the Baluch community. The state says, no, you cannot equate intra-religious or sectarian discrimination with persecution of a religious minority. It's not the same. But there's no authority in international law that makes any such distinctions. On the contrary, this international covenant of which India is a party categorically states that freedom of thought, conscience, and religion is not dependent on minority status. Besides, if you go by that logic, Ahmadis in Pakistan are technically not considered Muslims by the Pakistani state. The law then is underprotective and discriminatory in that it leaves out significant populations that may fear persecution. The second question that we can ask is, why choose these 3 countries? If the justification used is the return of persons of Indian origin, as the Act states, then Pakistan and Bangladesh would make sense. But what about Afghanistan? Afghanistan wasn't part of undivided India as defined by the Government of India Act 1935. In fact, Afghanistan was already an independent state by then. The only context in which Afghanistan would make sense is the Hindutva imagination of Akhand Bharat.
प्राचीन काल में अफगानिस्तान अखंड भारत का हिस्सा हुआ करते थे.
But we will get to that in just a bit. Question number 3. What about asylum seekers from other neighboring countries? According to the UNHCR data, India has more refugees and asylum seekers from Tibet, Sri Lanka, and Myanmar than, say, Afghanistan. In fact, only last month in November 2022, the governing DMK submitted to the Supreme Court that CAA is discriminatory for excluding Tamil refugees from Sri Lanka. So then the law's claim that its objective is to protect persecuted populations falls flat. Clearly, the criteria here is not need, but religion and country of origin instead. Because how can the basis be need if those who are not included are actually more in number and likely to be more in need than the ones that are being protected. Finally, why exclude Muslims? The basic rationale for this is that in the specified countries, Muslims form the religious majority and the law is intended for persecuted religious minorities.
क्या आप कहना चाहते हैं पाकिस्तान में मुसलमान पर अत्याचार होगा? बांग्लादेश में मुसलमान पर अत्याचार होगा? कभी नहीं हो सकता.
Except, like we spoke before, it doesn't take into account the Muslim sectarian minorities that are also being persecuted. So the qualification here again is religion, not persecution. Also, if we continue with the Indian origin argument mentioned in the Act, exclusion of Muslims becomes even more problematic. Because if you're talking about bringing back Indian origin people back to India, then what is the largest religious demographic to be displaced from the Indian subcontinent? Exactly. The government's defense for inclusion of some and non-inclusion of others is twofold. It first says to the communities not included that we already have the existing standard operating procedure that applies to all refugees in India open for you. And then closes dialogue by stating that it is the state that decides who gets to be a citizen, and this is a matter not open to judicial review. Which brings us to the big picture question in all of this. Is citizenship a right? And are there any international limits to a state's power when it comes to regulating nationality? In the JPC report that reviewed CAA, a Law Department representative actually says that it is not. Citizenship cannot be given as a matter of right. It is not anybody's fundamental right. International standards speak differently. Nationality is generally accepted as an inherent human right. Why? Because without nationality, you don't have any other political or legal rights. So while states do have a broad discretion to decide who gets to be a citizen, this power is not absolute. It has to be in compliance with international human rights and the principle of non-discrimination. In fact, India is actually party to multiple international laws that bind it to Article 15 of the Universal Declaration of Human Rights, which states that everyone has a right to nationality and is obligated to be non-discriminatory. By placing this burden of proof of citizenship on the individual, as is the case with the NRC, this right to citizenship is adversely affected. But you may say, not every distinction amounts to unlawful discrimination, and everyone has a right to nationality doesn't mean that one country has to give citizenship to everyone, right? That's true. But laws don't exist in a vacuum. There's political and historical context to them. So let's look at CAA in the context of the current dominant political ideology in India, which is Hindutva. Hindutva is the predominant form of Hindu nationalism and is part of the ideological makeup of the governing BJP. Now in this context, CAA fits very well with the Hindu nationalist narrative that A. Hindus have a natural right to citizenship in India, and B. Non-Muslim religious minorities face religious persecution in neighboring Muslim countries. And therefore, it only makes sense to offer citizenship to them. To which the liberal position says, no, our constitution is secular and therefore it is legally problematic to invoke religion as a criteria for selection. This binary politics of Hindutva versus liberals is largely the framework of debate which has emerged in response to the CAA. But Hilal Ahmed, an associate professor at CSDS, argues that this is a bit of a simplistic reduction. He says that while there is merit in the argument that CAA attacks the constitutional idea of a secular citizenship, contemporary Hindutva is not exactly anti-constitution. On the contrary, it appropriates the constitution instead. This is what he calls Hindutva constitutionalism.
ये बिल संविधान के किसी भी आर्टिकल को कॉन्ट्राडिक्ट नहीं करता।
Hilal traces the trajectory of Hindutva politics from an open critique of the constitution in the 1950s to demanding its re-evaluation in the 1990s to now hailing it as a holy book.
For my government, the Constitution is its real holy book.
Remember, the law is not just offering citizenship to Hindus by saying Hindus have a natural right to Indian citizenship. It is offering it to multiple communities. And it is not even using the term Hindu. Its language is much more legally sophisticated. It uses the term religious minority, which corresponds to a legal and constitutional framework. It's a legislation drafted by the Ministry of Law, mind you, and could only have become a law by claiming constitutional validity.
When we link Hindutva with constitutionalism, we actually mean that it is an interpretation given to the constitution from the perspective of Hindutva politics. Hindutva constitutionalism has got three very basic features. The first feature of Hindutva constitutionalism is that constitution is interpreted as a rule book, meaning that BJP leaders and RSS leaders, they make a very crucial distinction between the principles that are there which led to the formation of various articles of the constitution and the rules and explanations that are given in the constitution. So they argue that principles that were there in the constitution, the normative ideals, are settled thing, while there is a need to make rules more powerful and more more effective by implementing them with certain kind of force. The second characteristic of Hindutva constitutionalism is the idea of minority. Remember that Hindutva politics is not about majoritarianism, it is about the idea of minority, and this idea of minority is so central for Hindutva politics that's the reason why there is a Supreme Court case going on in which it is demanded that Hindus must be recognized as a minority in those states where they are in majority. CAA is also a good example of this trajectory, meaning identifying Hindus the position of Hindus in relation to the concept of minority. The third feature or characteristic of Hindutva constitutionalism is something called one nation, one constitution. And this feature was very creatively evoked when the debate on Article 370 took place. Hindutva politics is not interested in giving up the constitution completely. Rather, there is a systematic approach to appropriate constitution to nurture their own political moves and to justify them in legal and constitutional terms.
Granting citizenship to religious minorities also directly feeds into the BJP government's argument of Hindu victimhood, which has remarkable political capacity.
क्या हिंदुस्तान में हिंदू खतरे में है?
क्या हिंदुस्तान में आज हिंदू होना, हिंदुत्व की बात करना पाप हो गया?
47 तक भारत को इस्लामिक राष्ट्र बनाने का ब्लूप्रिंट भी तैयार किया जा रहा है।
2047 में भारत मुस्लिम राष्ट्र।
Hilal argues that this is the new long-term project of contemporary Hindutva.
Hindu victimhood is that it is inextricably linked to the idea of competitive victimhood. What is competitive victimhood? When we say that one entity is relatively marginalized to other entity, the first entity would have to explain itself in such a way that its marginalization is much higher than the entity B's marginalization. So suppose Muslims are, after such a commission, it is very well known that Muslims are marginalized in all respect. But therefore, there is in order to counter that, there is a constant effort to argue that Hindus are equally marginalized.
The CAA cannot be divorced from the context of the NRC and the NPR. And together, they produce a scenario that disproportionately affects the Muslim community. Besides, what happens if you don't make it to the list? It has been 3 years since CAA was passed, but the law is yet to be implemented. While we await its future political trajectory, what is of import is to remember the series of dialogues that it gave rise to around democracy, freedom, and equality. CAA brought in its wake a variety of mass protests. You had people's movements like Shaheen Bagh that reimagined nationalist symbols and was led by Muslim women. And you also saw the largest political participation by Indian Muslims in post-partition history. The people of the land refused to stay quiet in the face of injustice. They said to the state, "Ki hum dekhenge."